One of the questions that I get asked is, if someone tragically dies in a motor vehicle accident that's caused by the negligence of a driver, what rights do the surviving family members have? What claim for compensatory damages can they seek? Well, in this episode called How Do You Proceed with a Wrongful Death Action, I'll answer these questions and much more. Stay tuned. Hi, and welcome to the third episode of Season 2 of my vlog, Personal Injury Lawyer Tips. My name is Leroy Rudder. I'm a personal injury lawyer specializing in catastrophic impairment law. I'm also a published author of the LexisNexis Inc. book called Catastrophic Impairment Law in Canada, a director at Head Injury Rehabilitation Ontario, a co-chair of the Law Society of Ontario's annual solo and small firm conference, and the founder and owner of my law firm, Rudder Law Group. In this vlog, I'll be discussing how to proceed with a wrongful death action. If someone in your immediate family tragically passed away from a horrific motor vehicle accident caused by the negligence of the at-fault driver, then unfortunately the estate of your loved one cannot claim for an award in damages for his or her untimely death. However, if you are the surviving spouse, child, parent, grandchild, grandparent, and/or sibling, then you may claim for an award of damages further to Section 61 of the Family Law Act. The award of damages that you can claim further to Section 61 Sub 2 of the Family Law Act are as follows: actual expenses reasonably incurred for the benefit of his or her death, actual funeral expenses reasonably incurred, a reasonable allowance for travel expenses actually incurred in visiting him or her prior to death, during treatment or recovery, where prior to his or her death, as a result of catastrophic injuries, you provide a nursing, housekeeping, or other services, a reasonable allowance for loss of income or the value of the services, and an amount to compensate for the loss of guidance, care, and companionship that you might reasonably have expected to receive from him or her, if the tragic untimely death had not occurred. The last claim for an award in damages to compensate for the loss of guidance, care, and companionship is the largest and primary claim for damages in a wrongful death action, and as such, I'll be focusing on this one. If you want to learn more, however, about the various kinds of monetary compensation you can claim in a tort lawsuit for compensatory damages, then please watch episode number 3 of Season 1 of my vlog, entitled What Damage Awards Do I Get for a Successful Tort Action? Back in the day, at common law, no action lay for any loss in circumstances where the torturous conduct of the defendant caused another person's death. However, in 1846, in England, through an act for compensating families of persons killed by accidents, the tortfeasor was liable to an action for damages to certain prescribed persons in particular relationships with the deceased. The pertinent sections of this 1846 British Act was made part of the law of Ontario in 1847 with the introduction of the Fatal Accidents Act. However, Ontario's 1847 Fatal Accident Act was not interpreted to permit compensation for grief, mental distress, or solitium. Companionship was limited to pecuniary loss. However, it was eventually held that the Fatal Accidents Act permitted the granting of compensation to a child for the loss of his or her parent's companionship. This was affirmed in a 1967 Supreme Court of Canada case entitled Vana and Tosta. Prior to this affirmation, the prevailing fiction was that a child's loss of a parent's companionship was a pecuniary loss. Even though the Supreme Court of Canada affirmed that damages can be awarded in Canada for the loss of guidance, care, and companionship, the statutory scheme permitting recovery for same didn't become part of the law of Ontario until 11 years after. Why did it take so long? Well, following the Supreme Court of Canada's 1967 affirmation in Vana and Tosta, in 1969, the Ontario Law Reform Commission, in its report on family law, recommended that a full study be undertaken of losses, including losses which were non-pecuniary in their character, in both personal injury and fatal accident claims. The Commission recommended in its brief report that the legislation which was then contemplated limit recovery of damages in fatal accident claims to pecuniary losses, as the Commission assumed was the case under the Fatal Accidents Act. Finally, in 1978, again 11 years after the Supreme Court of Canada's affirmation, the Family Law Reform Act was proclaimed in force. It provided for the recovery of pecuniary loss in respect of personal injury and fatal accident claims. However, Section 60 sub 2 of the Act provided that recoverable losses in a fatal accident claim by certain relatives of the deceased may include damages for your loss of guidance, care, and companionship. The introduction of the Family Law Reform Act represented a major change in the scope of the quantum of recovery of damages in fatal accident claims. The Family Law Reform Act became the Family Law Act in 1990, after the statute was proclaimed in force by the Legislature of Ontario, which presently regulates the rights of spouses and dependents in regards to property, support, inheritance, prenuptial agreements, separation agreements, and other matters of family law. However, the purpose of the Family Law Act, specifically as it relates to wrongful death actions, is to create a legal right of action by the dependents of the deceased for their individual losses as a result of the death. Named claimants in a fatal accident claim are allowed to recover what they have lost, their dependency loss. Again, this statute provides that damages recoverable in a fatal accident claim may include damages for your loss of guidance, care, and companionship. The question, however, quickly arose again as to whether compensable damages for the loss of guidance, care, or companionship included essentially pecuniary losses. Well, the Court of Appeal for Ontario's judgment in a 1982 case entitled Mason and Peters put that debate to rest. In that case, the trial judge assessed guidance, care, and companionship compensation for a mother whose 11-year-old son was killed in an accident in April 1978 at $45,000. He assessed the deceased sister's damages at $5,000. After the Honorable Justice Robbins reviewed the relative meager damages awarded in cases involving the death of children under the former Fatal Accidents Act, he focused on companionship and said the following at page 33 of his decision, quote, "Whatever the situation may have been in earlier times when children were regarded as an economic asset, in this day and age, the death of a child does not often constitute a monetary loss or one measurable in pecuniary terms. The most significant loss suffered, apart from the sorrow, grief, and anguish that always ensues from such deaths, is not potential economic gain, but deprivation of the society, comfort, and protection, which might reasonably be expected had the child lived. In short, the loss of the rewards of association which flow from the family relationship and are summarized in the word companionship," end quote. So awards for loss of guidance, care, and companionship are not exclusively a monetary loss or one measurable in pecuniary terms, but it is rather a dependency loss. Although this sounded great in principle, a new problem emerged in regards to its consistent application in compensatory damage awards. Subsequent cases, which were decided under both the Family Law Reform Act and the Family Law Act, ultimately revealed the great disparity in guidance, care, and companionship damage awards. Since guidance, care, and companionship damage assessments were not consistent, in the interest of certainty, some called for conventional awards. An example of this was seen in the 1984 case entitled Gervais and Richard. However, as it turned out, the call was not heeded, which was evident in cases such as the 1986 case Nielsen and Kaufman and the 1987 case Dasiak and Lucas, where it was established that in assessing guidance, care, and companionship damages, the particular family circumstances in each case must be taken into account by the trier of fact. So this resulted in courts proceeding with a case-by-case analysis of family relationships, which has led to a range of guidance, care, and companionship assessments so broad as to defy the description as conventional. The Ontario legislature could have tried to address the disparity by moving towards a legislative scheme, such as exists in Alberta, where the Alberta Fatal Accidents Act provides that in the event of the death of a child under 18 years of age, the court is directed to award a specific amount of money for bereavement for fatal collisions occurring after May 1st, 2013, as $82,000 to a surviving spouse or interdependent partner, $82,000 to the parent or parents divided equally, and $49,000 to each surviving child of the deceased, no matter his or her age. Interest is also added to these amounts to the date of payment or settlement of the fatal car accident insurance claim. Unlike Ontario, this is done in Alberta without reference to other damages or evidence of damage. The Ontario legislature may one day consider the merits of Alberta's aforementioned system, but thus far, it hasn't yet. So, in Ontario, each case must be given separate consideration to measure what is essentially immeasurable and incalculable. I mean, how do you accurately measure and calculate the loss of a loved one to a surviving family member whose love for that person is so great that no amount of money can suffice? Well, judges and juries, the trier of fact, are left with the challenging, unenviable task of doing the best they can in each case where the assessment of damages for guidance, care, and companionship is required. So while reference to other guidance, care, and companionship assessments involving deaths of children is helpful to test the reasonableness of the award, it is not determinative. Each case must be considered in light of the evidence material to the guidance, care, and companionship claims in that case. The Court of Appeal for Ontario has consistently held that the guidance, care, and companionship compensation in each case must be assessed in an objective and unemotional way. For examples of this assessment approach, see the 1991 case Hamilton and Canadian National Railway Company, and the 2000 case Macartney and Warner. Since each case must be considered in light of the particular family relationship involved, assessments will, of course, vary. An appellate court will not lightly interfere with a properly instructed jury's assessment of damages. However, the reasonableness of the jury's assessment will be tested, but by comparison with assessments in other cases. This latter exercise has led to the establishment of a range of damages. So in a 2001 case entitled Toe and Toronto Board of Education, the Court of Appeal for Ontario essentially imposed a rough upper limit, as the Supreme Court of Canada did in respect of non-pecuniary general damages in personal injury cases, in the case entitled Andrews and Grand & Toy Alberta Limited. In this 2001 case, however, the Court of Appeal for Ontario deemed the high water mark for surviving parents of children who died in a fatal accident to be $100,000 in 1992 dollars, but the number is subject to inflation and must be adjusted accordingly. The Court of Appeal for Ontario noted at paragraph 37 the following about the high water mark as it specifically pertains to the surviving parents of a child who died in a fatal accident. Quote, "The assessments of $100,000 for each of Mr. and Mrs. Toe might be viewed as being at the high end of an accepted range of guidance, care, and companionship damages. The question that must be considered is whether those assessments are outside the accepted range of damages. In my view, the $100,000 assessments for Mr. and Mrs. Toe are not outside the range. Expressed in constant dollars, the $100,000 assessments for Mr. and Mrs. Toe are roughly comparable to the $45,000 guidance, care, and companionship assessment in Mason and Peters. In April 1978, the month of the Mason and Peters accident, the Consumer Price Index for Canada was 54.6. In February 1992, the month of the deceased death, the Consumer Price Index was at 127.1. Given that increase in the Consumer Price Index, it would take $104,753 in February 1992 to purchase the same basket of goods purchased for $45,000 in 1978. I view Mason and Peters to be an acceptable comparator for the purpose of assessing a range of accepted damages. In addition, I note that the $45,000 Mason and Peters guidance, care, and companionship assessment was referred by Justice Robbins as modest and an assessment that could in no sense be considered excessive. Although I think that the jury's guidance, care, and companionship assessments to Mr. and Mrs. Toe are high, they are not so high as to justify this court's intervention. In my opinion, there is evidence in this case that would support a conclusion that damages for guidance, care, and companionship in respect of the mother, father, and sister were justifiably assessed at the high end of what one might describe as an accepted range of damages. There was evidence of an extremely close relationship between the deceased and his mother and father. It was open to the jury to find that Mr. and Mrs. Toe suffered a substantial loss of society, comfort, and protection, all benefits that flow from the family relationship. I would not give effect to this ground of appeal." End quote. So the first takeaway is that this is an example of how an appellate court will not lightly interfere for properly instructed jury's assessment of damages. However, the reasonableness of the jury's assessment will be tested, but by comparison with assessment in other cases. In this case, the Court of Appeal for Ontario tested the reasonableness of the assessment of damages by comparing it with the assessment in a 1978 case, Mason and Peters. The second takeaway is that the high end of the range of a non-pecuniary Family Law Act claim, which was $100,000 in February 1992, increases along with the increase of the cost of a fixed basket of consumer purchases, such as food, shelter, furniture, clothing, transportation, and recreation. The increase in this cost is, of course, inflation, which is a persistent rise over time in the average price of goods and services, in the cost of living. The Consumer Price Index tracks how much the average Canadian household spends and how that changes over time. The Bank of Canada uses it to target inflation, which further to the Court of Appeal for Ontario must be factored in to the adjustment of the current value of the accepted high-end range of damages for guidance, care, and companionship that correspond with the increasing monthly consumer price index. The Court of Appeal for Ontario, in a 2010 case called Fiddler and Chiavetti, confirmed in paragraphs 79 and 80 the aforementioned method of using the monthly consumer price index in adjusting the current value of the high-end range of damages for guidance, care, and companionship. The Court of Appeal for Ontario and Fiddler and Chiavetti adjusted the high-end range of $100,000 in February 1992 to the high-end range of $125,000 in January 2005 to correspond with the increase in the Consumer Price Index from 83.3 to 105.3. As such, in order to ascertain what the current value of the high-end range of $100,000 in February 1992 is in your case, you first ascertain the Consumer Price Index in the month and year that your subject motor vehicle accident occurred, and then use the same aforementioned method of adjustment to correspond with the increase in the Consumer Price Index. In order to find out how much it would cost on current dollars to buy $100,000 in February 1992, you use the inflation calculator on the Bank of Canada website. Upon using the inflation calculator, you'll quickly discover exactly how much it would cost in present-day dollars to buy a basket of goods and services that cost $100,000 in 1992 dollars, which would include the following data: the percent change, the number of years, the average annual rate of inflation divided by the decline in the value of money, the consumer price index for the first year, December 1992, and the consumer price index for the second year, the year your motor vehicle accident occurred. For example, the cost of buying a basket of goods and services in 2023, which would cost $100,000 in 1992 dollars, is $188,137.60. So the high watermark for surviving parents of children who died in a fatal accident in 2023 is $188,137.60. Therefore, after factoring in inflation as directed by the Court of Appeal for Ontario and O.A.C and Toronto Board of Education, and affirmed by the Court of Appeal for Ontario and Fiddler and Chiavetti, you can ascertain what the high watermark is for the accepted high-end range of damages for guidance, care, and companionship in present-day dollars, specifically for the surviving parents of a child who died in a fatal accident. So how does the jurisprudence define guidance, care, and companionship? Well, the Court of Appeal for Ontario and O.A.C and Toronto Board of Education defined them as follows, quote, companionship consists of the deprivation of the society, comfort, and protection which might reasonably be expected had the child lived. It is the loss of the rewards of association which flow from the family relationship. Care includes feeding, clothing, cleaning, transporting, helping, and protecting another person. Guidance includes such things as education, training, discipline, and moral teaching. End quote. The Court of Appeal for Ontario and O.A.C and Toronto Board of Education refers to the decision in the 1981 case Thornborough and McKinnon, where the Honorable Justice Linden provided a much more detailed interpretation of guidance, care, and companionship as follows, quote, as for guidance, most of the guidance, that is, things such as education, training, discipline, moral teaching, etc., usually goes from older members to younger members of the family. But that is not universally so. Often it is the child who acquires some skill or knowledge which he imparts to the parents. Not infrequently, parents are taught by their children about such things as modern music, for example, rock and roll, modern styles, modern activities, modern morals. It is not a rarity that a child introduces a parent to a new sports activity, such as skiing or tennis, and gives guidance and instruction to the parent in mastering that sport. Of course, this is especially the case as a parent grows older and loses touch with some of the developments in the modern world. Children then are extremely important as teachers of their parents, as well as vice versa. Where the evidence supports it, therefore, an award can include a sum for the guidance that a child can give to a parent, as well as that which a parent can give to a child. As for the word care, I think a child can also give care to a parent. The Mason and Peters case is an example of that, where a young boy who was killed and helped to care for his mother, who was a paraplegic in a wheelchair and in need of his care. Thus, when a parent is ill, a child, even a small one, may assist in giving care. Care, I think, includes such things as feeding, clothing, cleaning, transporting, helping, and protecting another person. This is especially important in relation to parents who are elderly, whose children often help them with the daily task of living, such as shopping, getting around, attending at various medical advisors, and other events. Care, then, is a concept that can apply on proper evidence among all the members of a family, regardless of age. In relation to the notion of companionship, age differences are totally irrelevant. Members of a family enjoy the companionship of other members of that family, no matter what their ages. People of the same age welcome the company of the others in their age bracket, of course. But older people enjoy being with the young, and younger people enjoy companionship of older people as well. The companionship of a parent and child is a truly unique pleasure. The joy of sharing experiences of one's child is hard to surpass, whether it be sports, culture, conversation, or play. There are not many activities more enjoyable for a parent than to participate with one's child in the celebration of birthdays, graduations, weddings, the births of grandchildren, and all of the other landmark events in their lives. What greater joy is there than to be with one's child on religious holidays such as Christmas or Easter or Hanukkah? What could be a greater pleasure than to accompany one's child to a movie, a circus, or a hockey game? What can be more marvelous than to hear one's child laugh, to cuddle it before bed, or to watch it play with a dog? To see the enthusiasm for life in one's children often helps to restore one's own faltering commitment to a better world. Yes, companionship with one's children is one of the most prized of human experiences. To lose that is one of life's greatest losses. It was to provide compensation for that loss of companionship that the Ontario legislature inserted that language into the Family Law Reform Act in 1978. It was not meant to be treated as a trivial loss, for it is not. Thus, loss of guidance, care, and companionship can be suffered by each member of a family as a result of the death or injury of any other member of that family. Age is irrelevant. It is always an individual matter that must be established on the evidence in each case. This may differ in every family and of each individual in the family." End quote. Therefore, the jurisprudence and the evidence is shown that in the vast majority of cases involving the untimely, tragic death of a child as a result of a fatal accident, parents do receive much in the way of guidance, care, and companionship from their children, as well as the other way around. In addition to a tort claim, if someone tragically passes away from a motor vehicle accident caused by the negligence of the at-fault driver, then the spouse, children, grandchildren, parents, grandparents, and/or siblings may claim for death benefits through an accident benefits claim. Death benefits are payable under Section 26 of the Ontario Regulation 3410 Statutory Accident Benefits Schedule, which was issued under the Insurance Act. An insurer shall pay a death benefit in respect of an insured person who dies as a result of a motor vehicle accident, either within 180 days of the accident or within 156 weeks after the accident, if the insured person was continuously disabled as a result of the accident. However, no payments are payable to any person who dies before the insured person or within 30 days after the death of the insured person. Lastly, your first-party insurer shall pay a funeral benefit for an insured person who dies as a result of an accident. This amount is limited to $6,000 unless optional benefits are purchased. You'd also claim this through your accident benefits claim. If you want to learn more about the companion accident benefits claim and kickstarted the accident benefits application process, then please watch episode number 1 of season 1 of my vlog, entitled How to Get Your Accident Benefits Application Started. I hope you found this information valuable. If you want more information, then please read my blog called How Do You Proceed with a Family Law Act Tort Action. In my blog, I take a deep dive into wrongful death tort actions, the corresponding jurisprudence, and the rich history of the evolution of the award of compensatory damages for guidance, care, and companionship. I also provide links to other blogs such as What is the Cause of Action for Negligence Action in Tort, and What Damage Awards Do I Get from a Successful Tort Action, which provide additional information that you'll find helpful. My website is your one-stop source for answers to all of your legal questions concerning tort law, personal injury law, and catastrophic impairment law. If you want to book a free consultation with me, then please visit my webpage at RudderLawGroup.ca and click on the free consultation button at the top of the page. Let us be your rudder that steers your legal ship in the right direction. Please subscribe to my YouTube channel and click the like button if you found the content valuable. There you'll also find other vlogs of valuable content on tort law, personal injury law, and catastrophic impairment law. Thank you, and I'll see you soon in episode 4 of season 2 of Personal Injury Lawyer Tips, where I'll bring you more useful legal information.